Hello, guys. Good evening. I am Irvin Bautista, and welcome to my channel. I do apologize for not really posting a lot of videos about legal topics in Canada. I do apologize for that just because I'm so busy with work, especially with transitioning from being a student in law and now becoming a lawyer, and from transitioning from one law firm to another. So many things have happened, especially when I moved to Central Alberta, and now I have to go back to Edmonton, where I am from, just because of certain situations that are beyond control. Unfortunately, our law firm in Central Alberta has ceased operating just because the partners have retired. I've had so much fun working there. I've had so much fun networking with a lot of Filipinos. And basically, I'm happy because I'm the only Filipino lawyer in Central Alberta. And the good thing about working in Central Alberta is the fact that I can now access Edmonton and Calgary all at the same time. Because if you are from Edmonton, if you have a client who's located in Calgary, it would take you 3 hours just to go there and another 3 hours to go back. So it's expensive, it's tiring. So that has been some reasons for me not to accept clients in Calgary. Red Deer or Central Alberta is just 1.5 hours away from Edmonton. So it's kind of bearable to actually travel. It's still far, but it is bearable. So now that I used to work in Sylvan Lake, it's part of Central Alberta, so it was actually a good location because I can get to Edmonton for 1.5 hours, and then of course in Calgary for another 1.5 hours. So Central Alberta is in between Edmonton and Calgary. So basically there's a break. So if there are clients who are in Calgary and wanting to actually retain me, I am actually happy to say yes. But of course, at the same time, of course, if I have clients in Edmonton, I would happily say yes to actually serve them again. But of course, Central Alberta, there is an unserved Filipino community there. And how I wish I could have continued working, but fate would have it. And yeah, I have to go back. Okay. But nonetheless, so many things have happened in my life that I wanted to actually discuss with you a topic that I was actually remiss in discussing. I have posted a previous video about divorce in Canada. It's just an overview, and you would know the grounds for divorce in Canada. Okay? I will be posting the link below in the comment section so that you'll know and you can refer to that. So just to refresh your memory, reiterate that there are 3 grounds for divorce in Canada. I am talking about Canada because divorce stems from the Divorce Act, which is a federal legislation passed by the federal government, meaning this legislation applies across all provinces of Canada. This is not limited to Alberta. This is not limited to British Columbia or any other provinces for that matter. This Divorce Act will apply in Canada, wherever you may be in Canada. Except probably, of course, Quebec. But that's a different story. Now, just to reiterate, there are 3 grounds for divorce. One would be adultery, one would be cruelty, and one would be separation for at least a year. Okay? Just to provide you with a brief description of the following. First, adultery, when either person has had an affair, probably sexual intercourse or sexual intimacy with another person, then that would constitute as a ground. Okay, of course, you have to prove that there wasn't sexual activity between 2 persons before you can proceed with filing for divorce. The other one would be, so if the other spouse or one spouse has committed cruelty against the other, then this could be a ground for divorce. How would you define cruelty? Cruelty is the person of another, of the spouse or the other spouse. Cruelty, which involves violence, verbal abuse, or excessive drug use. Anything that harms the relationship. Okay, if there's any physical abuse in the family, mental abuse, then cruelty can be present. But other than these two, the most common ground that is being used right now is separation for at least a year. Mind you, it has to be at least 1 year of separation from the other spouse. You might ask, Irvin, how about if we decided to actually separate from bed, okay, but we are still living under one house? Does that mean that we are separated or not? Technically speaking, courts are actually allowing that kind of situation. Even though you are still living under one roof, if you have actually been living or sleeping in different rooms, as long as there is, as long as both parties know that they have been separated, then that constitutes separation. The reason being behind that is because there are situations where separation would definitely bring hardships or economic hardships towards the other person who is leaving. Of course, no one anticipated, if you're in a relationship, no one anticipated that you'll be separating, right? So basically, you are invested in this relationship. You are not ready to actually say, you are not ready, you are not financially ready to actually move out. And in order for you to relieve your economic hardship, courts allow two people to be living under one roof and basically considered as separated. Okay? Now, going forward, now that we have known the grounds for separation, the ground for divorce, let us now know what are the requirements for filing for divorce regardless where you are married. You may be married in the Philippines, you may be married elsewhere, you may be married in Canada. Regardless of your marriage, regardless of the place of your marriage, as long as your marriage is valid and and recognized and valid in Canada, then you are actually entitled to file for divorce. Other than that, of course, you have to be at least residing in Canada for at least a year. Okay, meaning that you have to be residing in Canada in one way or another to be able for you to file for divorce. Now you may ask, Irvin, in that case, should I be? Does civil status matter in terms of applying for divorce in Canada? I would say no. Okay, even if you're not a Canadian citizen, even if you are a permanent resident, meaning you still are a citizen of your home country and you're not a Canadian citizen, or if you are here not as a permanent resident but only on a temporary resident visa, such as work permit or study permit, as long as you are residing here for at least a year, okay, then and there's some form of semblance of residing in a permanent fashion, then you are allowed to actually file for divorce. So, Irvin, do visitors have the right to file for divorce? Unfortunately, no. Okay, just because visitors are only expected to stay in Canada for a maximum of 6 months. However, regardless of the extensions applied for mostly by visitors to extend their stay in Canada, you are not expected to stay in Canada, or there's no form of permanency in terms of you staying in Canada. So, unfortunately, visitors cannot apply for divorce in Canada. So, whether you are working, whether you are studying, and then eventually go on a postgraduate work permit where you are allowed to work after you study in Canada, then you can actually go and apply for divorce. Okay, regardless of the marriage, of the place where the marriage took place. As long, say for example, you're residing in British Columbia, Saskatchewan, Manitoba, Alberta, whatever province you may be in, you are entitled to apply for divorce. Okay. Now that we have covered the grounds for divorce, and now that we have covered the requirements for filing for divorce, now you might ask, Irvin, how do we proceed with the divorce application? So, of course, before we proceed with filing an application, we have to know whether this is going to be uncontested, meaning the other party will not contest the application, or if the other party will actually contest the divorce application. Before we proceed with determining what kind of application we are going to file, we have to determine first if there are any issues to be resolved during the divorce application. Will there be any issues about child support if there are children of the marriage? Would there be any issues about spousal support? If, for example, the spouse is claiming for spousal support after their separation. And lastly, would be if there are any division of matrimonial properties, properties that have been acquired, purchased, or any other assets and debts that both parties have incurred during their relationship, and that both parties will have to actually equally divide amongst themselves, right? If there are no issues, say for example, Irving, we don't have any children, I don't have, my spouse is a successful professional, I'm also a successful professional, we've been both working. If there are no issues about spousal support on that, and if you don't have any properties together, if you don't have any debt, say for example, we were actually just renting the place, even though we got married, we have not commingled our finances, bank accounts, investments, even our, say for example, life insurances or any insurances for that matter. If you have not commingled that and there are no issues to actually resolve, then uncontested divorce might be a good way, might be a good route for you to take. Okay, uncontested meaning the other party will not contest the application because there are no issues to be resolved except for the fact that, hey, let's go separate ways and terminate our marriage. But if there are issues about any of those, if there are issues that need to be resolved, then basically you have to actually resolve that. If you cannot resolve it yourself, then you would have to have the court resolve that for you. Okay, so most the common issues that I've been encountering for my clients is mostly on child support. Okay, because of course living in Canada is really really hard, and let alone having kids. Of course, the federal government and the provincial government, if I think so, but the federal government provides some form of assistance when you have children, right? They provide you with a certain amount of money every month to assist and help out with your children. But I don't think that's enough because it's not the amount that one parent is receiving or the parents are receiving is not enough. Okay, now there might be some child support issues because of course one parent who's actually taking care of the children are having a hard time spending for them, and the other parent is absent or is not supporting the children, then the courts will have to decide and determine how much of a child support is to be given by the parent or the parents. Okay, of course we are going to discuss about child support on a separate video because that topic is, let alone, a very lengthy discussion to have. Next would be spousal support. Spousal support, if there are any other entitlements or if the other spouse is claiming for support, just because, of course, there's an economic disadvantage once they separate. There could be some merit to filing or claim for spousal support. But again, it might be too complicated to discuss that right now, just because, of course, spousal support, there are some thresholds that need to be met and qualifications before a spouse can be entitled to a spousal support. And lastly, of course, division of matrimonial property. When you get married, you don't actually anticipate that you're going to be divorcing, especially in our culture, the Filipinos. But it happens, right? You're not in the Philippines anymore. Philippines, although there is no divorce, there's annulment, but you're not in the Philippines anymore. You are in Canada. And if you decide to go for divorce, hell, why not, right? Now, of course, when you get married, you acquire properties. Especially in Canada, a lot of Filipinos are purchasing properties for them, for the family, right? And if there's a breakdown in marriage, of course, you have to discuss about dividing the property. Now, of course, when you have any joint properties or debts or assets with your spouse, then definitely once you separate, you have to terminate those and you have to sever the joint. You have to divide any assets or debts that you have acquired and incurred during your relationship. Of course, there are some exceptions, but generally speaking, you have to divide those. You can either sell the property or you can actually buy the other out, right? Say, for example, you've got kids, you've got a family home. Um, of course, it would be right now, considering that the economy is not good, then you might be able to go and say, no, it's going to be very detrimental for us to purchase a new home. So why don't I just buy you out? Or whoever buys someone else, especially if there are children, right? You don't want your children to be actually living in the streets or having a hard time adapting to a new environment. So if the other person has the capacity, has the financial capability to actually buy the other person out, then why not, right? Now, so if there are issues to be resolved, then that is a contested divorce. Because, of course, one would want this, the other would want that, and now, of course, there's a conflict, and of course, because of that, you have to have the court decide for the both of you. Now, if there are no issues, and say, for example, your separation is amicable, you don't have any properties together, you don't have any debts, you don't have any you don't have any problems with support from the spouse, you don't have any problems with child support, then that could be uncontested. Or if both of you are actually amicable and friends and you have decided to say, okay, we remain to be friends and we want to sever our relationship, our marriage, then you can go for joint divorce. Joint divorce is the fastest and easiest way for you to get divorced in Canada, just because both parties are working together to actually sever their marriage, which is very, very one of the things that us lawyers and courts actually want to see. But of course, you cannot force your clients to be cooperative with the other if there are a lot of issues to discuss and to be determined. So yeah, so there is a joint divorce, uncontested meaning uncontested, wherein the other party, the party would be filing for divorce. The other party says, okay, I hate you, just file it, I don't care, go for it. And joint divorce is under uncontested divorce in the sense that joint divorce, okay, we sit down, okay, we talk about our differences, we talk about ending our marriage, okay. Let's say, for example, if we have kids, say, for example, we have issues about spousal support or division of matrimonial property because we have properties. If both of you agree on how to or divide the property, if you both agree to say, for example, okay, this is the child support amount that I'll be providing, and if you agree to say, for example, this is the spousal support that I will be giving, then by all means, joint divorce is the best way to go. Okay? So, to recap, we have discussed the grounds for divorce, because Divorce Act is a federally legislated law, and this applies wherever you may be in Canada. Secondly, in terms of the requirements for applying for divorce, okay? And of course, when you have applied for divorce, before applying for divorce, you have to know which route you are going to take, either uncontested or joint divorce or the contested. I will see you around. Okay. So stay tuned and I will see you in my next video. Thank you.